security, so might want on the record that I am here since I'm not signed in at the front.
Morning. Welcome to our Legal Review Board meeting. Today's date is October the 7th, 2013. Time is 8:55 a.m. And we have present our chairman, Brother Eddie Roberts, Commissioner Don Parr, and myself, Nate Jackson, which is the chair. And also we have Director Leon Striblin. We have staff, Leslie Hull, Barry Whitson, Jason Gilliam, Attorney Anthony Glandorf, Bob Weaver, Darrell Nobley, Attorney Robert Ryan, and Attorney Merkel sitting back there. So we got a lot of attorneys in the house this morning. Again, this is our Legal Review Board, and I'm going to turn the meeting over to Attorney Glandorf.
Good morning.
Morning.
I'll go ahead and begin the legal report for October 7th, 2013. We have 58 individual itemized cases to be read to you all. If you all have any questions or anything, just please stop me while I'm reading, and we can go over those. The first one, case number 2013008951. Here, anonymous complainant alleged that a respondent dealer changed his name without providing notice to the commission administration. Upon review of the complaint, the respondent had obtained the required name change. I recommend that we close this. The respondent received the change of name for the dealership. Number two, case number 201. An internal complaint was opened regarding unlicensed activity as a dismantler recycler. The allegations were not sustained upon the information that was provided to the commission. I recommend that we close this case. Number three, case number 20130088481. Here, the complainant was a neighbor who alleged that the respondent, an unlicensed individual, was conducting unlicensed activity at his residence. An investigator had previously stopped by this residence and had verified that 3 vehicles were listed for sale. All of the vehicles were titled in the owner-respondent's name. That is less than 5 vehicles that were found. As such, no unlicensed activity is sustained. I recommend that we close this with no violation being found. Number 4, case number 20130088781. Here, the respondent is a licensed dealer who purchased the assets of a previous motor vehicle dealership. Prior to obtaining its own motor vehicle dealer license, the respondent admitted that it sold 2 motor vehicles and issued temporary tags purchased by the previous dealership. I recommend an authorization for a civil penalty in amount of $500 for unlicensed activity to be settled by consent order or formal hearing. Number 5, case number 201300839. Here, the complainant is an out-of-state consumer who alleged that he purchased a motor vehicle from the respondent dealer who failed to provide him with registration for the vehicle. An investigation was conducted. The complainant would not communicate with the investigator to provide further details for this information. Due to this, I recommend that we close this complaint, insufficient evidence of violation. Number 6, case number 20130088491. Here, the complainant is a consumer who alleged that the respondent dealer would not provide title to a vehicle that was purchased. Investigation was conducted. The complainant could not be found for further details. As such, I recommend that we close this with no violation being found. Number 7, case number 20130098841. Here, the complainant is a consumer who alleged that she purchased a motor vehicle in 2012 and was told by the respondent dealer that she was required to purchase a GAP policy in order to obtain financing. The complainant recently had traded in the vehicle. The respondent denied the allegations and canceled the GAP and for a refund of the unused policy. The GAP contract signed by the complainant stated in bold letters that it was not required for financing approval. I recommend that we close this case, no violation being found. Number 8, case number 20130100451. Here, the complainant was a consumer who alleged that the respondent dealer failed to provide title and registration for a vehicle purchased. The respondent replied, stating that it had lost title after receiving it from its floor planner. The respondent issued 3 temporary tags to the complainant during the interim. The respondent then provided a copy of the registration to the complainant. Due to this, I recommend authorization for a civil penalty in the amount of $500 for issuing the third temporary tag to be settled by consent order or formal hearing. 9, case number 20130088781. The complainant is a consumer who alleged that respondent dealer illegally repossessed the vehicle sold. The respondent provided documentation of the contract signed by the complainant and payments received. The documents did not show that the respondent engaged in any false, fraudulent, or deceptive act. I recommend that we close this for no violation being found. Number 10, case number 20130100851. Here the complainant is an out-of-state consumer who alleged that the respondent dealer misrepresented the type of transmission that was present on a vehicle that he purchased via eBay. The vehicle was a 1955 Chevrolet. The vehicle was sold as is, sight unseen. The complainant chose not to inspect or test drive the vehicle prior to purchase. The eBay listing indicated that the vehicle had a rebuilt M21 transmission. The complainant asserts that the vehicle arrived with a T10 transmission with mechanical faults. The complainant has not provided sufficient proof to substantiate its claim as to what type of transmission was in the vehicle at the time of purchase. The respondent states that it's his belief that the vehicle had an M21 transmission at the time of sale, that they represented such from their mechanics who state that this was the transmission that was present. As such, there's insufficient proof to show a deceptive act on part of respondent, since we cannot actually determine what transmission was on the vehicle at the time of sale. Recommend that we close this for insufficient evidence of a violation. Number 11, case number 20130088881. Here the complainant is a consumer who alleged the respondent dealer engaged in deceptive acts. The complainant did not provide a specific set of facts regarding this. The respondent replied stating the vehicle was repossessed at the time of repossession had been stripped down at the home of the complainant. The respondent stated they attempted to collect the deficiency, at which time this complaint was filed. I recommend that we close this, no violation being found. Number 12, case number 201300981. Here the complainant alleged that respondent dealer is holding the title after the vehicle was paid off. The respondent stated that on the day the vehicle was sold, the salesperson failed to include sales tax on the contract. The respondent alleges that the complainant did not engage in good faith upon the contract. From the documents presented, there is no evidence of deceptive acts or fraud on part of the respondent. It appears this issue is between the parties as contractual. I recommend we close this with a letter of warning. There's contractual issues between the parties. And I could tell you more facts, but it really appeared that the person who purchased the vehicle here was not attempting to negotiate in good faith with the dealer on the tax issue. Number 13, case number 201300851. Here the complainant and purchaser alleged the respondent dealer sold him a vehicle that misrepresented the mileage of the vehicle. This was a semi-vehicle, I believe. The respondent obtained the vehicle as a trade-in with 555,000 miles upon it and disclosed this mileage to the purchaser. 2 years after the purchase, the complainant alleges that an onboard diagnostic read that the vehicle at the time of sale would have actually had around 800,000 miles on it. That would appear that a rollback was possible, but there's insufficient proof to indicate that the respondent actually had no knowledge of this or had engaged in this. The respondent attempted to pay the complainant the difference in value. The complainant refused this offer. I recommend that we close this with insufficient evidence of deceptive act on part of the respondent and refer this complaint to the Tennessee Department of Safety for possible investigation on odometer tampering. From the documents that I had in this case, we could see that at the time of the vehicle that the dealer purchased it, it did indicate on his bill of sale the actual 555,000 miles on it. So from what I saw, I don't believe that our respondent here had any part to do with rolling back an odometer or anything like that. I believe who needs to be investigated is possibly the person who the dealer purchased it from, which I believe was out of state, not in Tennessee. Number 14, that's his case number 20130100481. Here the complainant was a consumer who alleged that he purchased a vehicle from an individual via Craigslist. The complainant alleged the vehicle was later found to be water damaged. The complainant conducted his own investigation and alleges that the seller misrepresented himself as a different person. This office could not determine the true identity of the seller. He was selling as an individual. The seller's cell phone could not be traced. We couldn't determine that with our investigative resources. There's insufficient proof that this individual sold more than 5 vehicles in a year. As such, I recommend that we close this. There's insufficient evidence of unlicensed activity. Here the respondent is a dealer who alleged to be operating a second business in the same location as its dealership. The photographs of the location do not indicate two businesses are co-located without proper separation. Per our rule, I recommend that we close this insufficient evidence of a violation. Number 16, case number 20130. The complainant alleged that she sold her vehicle to the respondent, who was an individual, and after such time received parking tickets in her name for the sold vehicle, and that the vehicle title was still in her name, meaning she traded in the vehicle, sold it, and it had been in her name for the last 2 or 3 years. She indicated that the respondent acknowledged liability but had not paid off such tickets. I recommend that we close this. It's a contractual matter between the respondent and the complainant. The respondent is not a licensee of ours at the time. The complainant should have a bill of sale absolving her liability of ownership. And there's no evidence of fraud or deceptive act on part of the respondent. Number 17, case number 20130129191. Here the complainant alleged that he purchased a vehicle and did not receive title with a release of lien from the respondent. The respondent stated that the title was given to the complainant at the time of sale with a release of lien, and that complainant has lost the title, but they will assist in obtaining the duplicate. As such, I recommend that. 18, this is case number 20130111971. Here the complainant alleged that after purchase of the vehicle, it began to have mechanical difficulties. Respondent replied, indicating the vehicle was sold with no promises. It was sold as is, with no promises of repairing any defects. Limited warranty with a deductible was sold on the vehicle, which can be applied for by the complainant. So, I recommend that we close this, no violation of fraud or deceptive acts being found. Number 19, case number 20130092211. Here the complainant was a dealer who alleged that a person near him was engaging in unlicensed activity near their licensed location. An investigation was conducted which did not discover the unlicensed activity. The investigator met with the complaining dealer, who confirmed that this activity had ceased. I recommend that we close this insufficient violation, nor could we actually find who was listing the vehicles at one point in time. 20, case number 201301261. Here the complainant is a consumer who alleged that after purchase of a vehicle from a respondent dealer, he could not obtain title or registration. The respondent replied indicating the vehicle was sold under special conditions, that documentation from the county clerk to the state was lost in their transition, and the respondent is working to obtain title and registration. We did send the surety bond information for the complainant. Recommend that we close this, no violation being found. The surety bond information has been sent. Number 21, case number 201300661. Here the respondent is a dealer. Was issued a notice of violation for failing to have a temporary tag log. The respondent disputed this and provided a temporary tag log they indicate was the log that they had at the time. The notice of violation didn't provide sufficient evidence of the violation as to what was missing or parts of the log. I recommend that we close this with a letter of warning. Number 22, case number 20130072201. Here the complainant is an ex-employee that alleged that the respondent dealer was requesting sexual favors in lieu of payments. An investigation was conducted, and it was a very thorough investigation with 2 investigators. The investigators met with the respondent, who I believe was 83 years old at the time, and respondent's attorney. The investigators did not find any evidence to substantiate the allegations. The complaining ex-employee refused to participate in the investigation and recanted on her original complaint. I recommend that we close this, no violation being found. Number 23, case number 20110289991. Here the respondent dealer was alleged to be conducting unlicensed activity by utilizing an unregistered name and location for the sale of motor vehicles. This case is related to an existing case, which was number 20120190022, in which the commission has already authorized a civil penalty in amount of $8,500, which has been agreed to by the respondent dealer, and I recommend that we just close this in connection with that previous case. This is really just to clean that up. Number 24, case number 20130133391. Here the complainant consumer alleged that the respondent dealer would not provide an early payoff amount for a vehicle purchase and financed by the dealer. Further, the complainant indicated that the dealership went out of business and should not be able to collect the accounts. This office found that the dealership went out of business and sold its accounts. This company provided payoff information to the consumer who does not agree with the amount, and that's their issue. I recommend that we close this, no violation being found. Number 25, case number 20130073031. Here the complainant consumer alleged that the day after they purchased the vehicle, it began to have mechanical failures. The complainant stated that the deal was rescinded, wherein they purchased another vehicle from the respondent, which also had mechanical problems and failures. There's no evidence of a deceptive act or failure to abide by any warranty. I recommend that we close this insufficient evidence of a deceptive false act. Number 26, case number 20130133921. Here, this complaint was originated with an internal generated inspection from the Motor Vehicle Commission. The dealer respondent was suspected of failing to maintain its facilities. However, the investigator met with the owner. The report indicated the business appeared to be co-located with another, that the signage was incorrect, and that the vehicle was parked in an area had no signs on the door for another business. None of this was substantiated by documents or other photographs that we had from the investigation. It's an ongoing issue with this, and I've addressed it with the new Director of Investigations so that we can get better evidence. As such, I recommend that we close this with insufficient evidence of a violation. Number 27, case number 20130142881. Here the complainant is a third party who alleged that the respondent dealer was selling a suspicious add-on product, which on the documentation is vehicle simple interest insurance and debt cancellation coverage. The respondent provided copies of the documentation from the deal file that shows the purchasers initialed by their names, indicating that they agreed to and requested the required coverage. Recommend that we close this, no violation being found. Case number 20130143331. Here the complainant is a county clerk that alleged the respondent dealer provided false documentation to the county clerk's office. Specifically, it provided a retail installment contract which did not note the amount of taxes collected. A copy of the contract confirms that the contract fails to specify to the purchaser what the total amount of taxes to be paid was. The respondent replied with a copy of a 6-month state tax returns. However, the respondent did not address this particular sale. This office previously provided documentation to the Department of Revenue regarding this dealer and possible issues. I recommend an authorization for a civil penalty in amount of $1,000 for false or deceptive acts for failing to indicate the amount of sales tax to be paid. Is to be settled by consent order or formal hearing. Number 29, case number 20130167171. Here the complainant is a consumer who alleged that the respondent dealer repossessed her vehicle and would have done so illegally. The respondent provided a copy of the contract outlining payments to be made along with all payments received by the complainant. From these documents, it appeared the complainant was in default. As such, I recommend we close this, no violation being found. Number 30, case number 20130106261. Here, this is an internal complaint that was opened by a respondent dealer during a biannual inspection of respondent's location by a commission inspector. The respondent's agent refused to allow the inspector to examine the records as part of the inspection. The inspector left the location, called my office. I communicated with the dealership, who apologized for this, indicated that the employee was his wife, and he asked the inspector to return that he would be present. The inspector returned, conducted the inspection without incident. I recommend that we close this with a letter of warning. Number 31, case number 20130159491. Here the complainant consumer alleged that the respondent dealer incorrectly collected sales tax upon a vehicle that was leased and later purchased under the option. Respondent replied with documentation, all of which showed correct sales tax collected. The lease portion paid taxes by month. The purchase option calculated taxes at the beginning of the sale. This is what confused the complainant and why the complaint was lodged. I recommend that we close this with no violation being found. Number 32, case number 2013003909120. A sale of a vehicle at auction. The complainant consumer alleged that he purchased a motor vehicle through an auction company via an internet site from respondent who was an auctioneer and could not obtain a title. The title was eventually provided to the complainant. An investigation was conducted and found that the auctioneer was engaging as a motor vehicle dealer by selling vehicles on behalf of another without being licensed as a motor vehicle dealer or public automobile auctioneer. I recommend that for the auction company under 2013003091, the authorization of a civil penalty in amount of $500 for unlicensed activity, and to close with a letter of warning under 2013003092, 3093, who are the individual auctioneers who worked for the auction company.
Question, Mr. Chairman, about this case. Are these 3 violations? I see only 1 fine recommended for one of the cases.
Yes, this is only one actual vehicle being sold through the auction. So this is actually one case. It's 3 different entities on the case.
Different entities on the case.
Yes.
So one is the licensed auctioneer, one is the auctioneer.
The other was an auctioneer apprentice, I believe.
So they're going to split this fine, or who
No,
are you holding accountable here?
I would rather hold the auction company accountable for the one who's listing the vehicle, and not the individual auctioneers, because I don't believe that. Actually, I'm not too sure, but I'd rather hold the auction company accountable for the sale of the vehicle and not the individual auctioneers who did the auctioning. Since it was on the internet, it wasn't a live called auction.
So this is only for one transaction?
One-
Okay, thank you.
Number 33, this is case number 2013000521. Here, this is a complainant consumer alleged that the respondent dealer failed to provide registration for a vehicle purchase and provided more than 2 temporary tags. An investigation was conducted. The investigator found that the respondent had issued 5 temporary tags to the complainant. Registration was never provided to the complainant. The complainant returned the vehicle. The respondent had purchased the vehicle at auction. They had lost the title and had difficulty obtaining title from the registered owner in Florida. This was confirmed by the selling auction. During the investigation, the respondent could not provide a copy of a temporary tag, did not have a temporary tag log at all. As such, I recommend authorization for a civil penalty in amount of $3,500, $500 being for the 3rd illegally issued temporary tag and $2,000 for failing to maintain to have a temporary tag at all, to be settled by consent order or formal hearing. Number 34, case number 2013009761. Here the complainant is a dealer who alleged that the respondent dealer misused the temporary tag by providing to a person who was not a customer. The respondent dealer denied such, stating that the tag was stolen. The individual to whom the tag was provided could not be found for questions or more information. There is not sufficient evidence that a tag was misused. However, there was no explanation really from the respondent dealer. As such, I recommend that we close this with a letter of warning. Number 35, case number 2013006491. Here the complainant consumer alleged a bait and switch against respondent dealer after visiting the location and asking to view vehicles within a certain price range. The complainant alleges that prior to the consummation of the deal, the sales manager indicated that the vehicle shown was the incorrect vehicle and that one of the same year and model had been quoted mistakenly. The complainant viewed the vehicle actually priced and decided not to purchase it. An investigation was conducted and found that the vehicle was not advertised by the respondent, so the complainant in this case did not come to the dealership looking for a specifically advertised vehicle. Further, there were in fact 2 vehicles of the same year and model on the lot. It appears the issue was likely due to a miscommunication of the correct vehicle. I recommend that we close this with a letter of warning regarding communication of vehicle prices to consumers. Number 36, case number 2013008611. Here the complainant consumer alleged that the respondent dealer sold her a motor vehicle that had purchased. The complainant alleged that the respondent failed to post the buyer's guide. The respondent admitted to such, but indicated the bill of sale says that indicates the certain disclosures. The complainant refused to provide a statement to the investigator and participate in investigation, which is difficult for us to actually prove the allegation. I recommend that we close this with a letter of warning. Case number 2013005841. Here the complainant is a consumer that respondent dealer, excuse me, I'm gonna start over. Here the complainant consumer alleged that the respondent dealer provided her with a false temporary tag, and further that the respondent failed to provide registration. An investigation was conducted. The investigator found that the registration was eventually provided to the complainant. Sorry. The respondent indicated that he had provided a false temporary tag to the complainant, but was under the belief that such tag was allowed. He had purchased this tag at Birmingham auction. The tag stated this car was sold by a licensed motor vehicle dealer. The respondent had been interviewed by the Tennessee Department of Safety and now ceased providing such tags. I recommend a civil penalty in the amount of $500 for committing a false act of providing this false temporary tag. With this respondent, I think we did the same thing at the last meeting on the same respondent. There are complaints coming in from the past when he had used these things, so every time we get a new complaint, I look at it for another false temporary tag, but to my knowledge, they have ceased doing that now. Number 38, case number 20130092221. Here the complainant purchaser alleged that the respondent dealer engaged in deceptive and false acts in the course of the purchase of a motor vehicle. The respondent sold the vehicle to the complainant in November 2013. The bill of sale indicated for payments over a period of time. Payment start, end dates, and periodic payments were not listed, so it did not comply with Regulation Z, Truth in Lending Act disclosures whatsoever. The complainant was issued a traffic violation for driving on an expired temporary tag. The respondent eventually repossessed the vehicle in May of 2013. The respondent never titled the vehicle in the name of the complainant, though the vehicle had actually passed emissions inspection, which is generally a reason why dealers tell us that they haven't registered a vehicle. The respondent admitted to issuing 3 temporary tags. The respondent refused to title and register the vehicle until the vehicle was paid off. I recommend an authorization for a civil penalty in the amount of $2,000, that being $500 for failing to comply with the Regulation Z and repossession on such, which would be deceptive. $500 for issuing a 3rd temporary tag, and $1,000 for the deceptive act of failing to title and register the vehicle after they had agreed to, per the contract, to be settled by consent order of
8, I think is wrong. It should be November 2012 because
You're right.
November 13 haven't
Yes,
gotten
that would have
here.
been sold prior to. Thank you. I'll make that mark there. Case number 20130104441. Here the complainant is a consumer who alleged that the respondent dealer engaged in fraudulent acts by failing to provide registration for a vehicle purchased and financed in-house. Investigation was conducted. The respondent could not provide a record for the issuance of temporary tags to the complainant. The respondent sold the vehicle in 2011 to the complainant. The respondent has not titled the vehicle into the name of the complainant. Title is in the name of the owner who sold the vehicle in 2010. The respondent alleges that the complainant has a $465 balance due on the vehicle and refuses to register the vehicle to the complainant. The bill of sale states, "Sales tax must be paid before you get your tags!" exclamation point. The respondent stated that they do not have proof of remitting any sales tax to the state though the complainant has paid over $5,000 thus far for the vehicle. I recommend an authorization for a civil penalty in the amount of $1,500. $500 for failing to keep a record of the issuance of temporary tags, $1,000 for fraudulent acts of failing to provide registration until the vehicle is paid off, and failure to title the vehicle into the complainant's name, to be settled by consent order with formal hearing. Number 40, case number 201301261 and 201301262. This is one case, 2 different players, 2 different persons. Here, anonymous complaint alleged that the respondent was misusing dealer tags and illegally using new dealer plates. An investigation was conducted. The investigator could not substantiate any of these allegations. I think she spent 2 days looking at this case, and it just was not true. As such, we recommend to close, no violation being found.
When an anonymous complaint comes in, Mr. Chairman, if I may, is that in the form of an email or a phone call? How's an anonymous complaint? Jason, do you? Are there a large number of anonymous complaints?
Part of the department's SOP, standard operating procedure, is that anonymous complaints are discouraged. And they truly are, because they could just be a phone call, just kind of somebody.
I wonder if you should even investigate an anonymous complaint.
In this case, there was photographs that were actually provided, multiple photographs, and I believe as we were reading it, we suspected it was probably a dealer licensee. So we had the investigator go out there. It was against the dealer, and it appeared to be probably from a dealer. So we had an investigator go out and look at this and see what it was. But generally, for many anonymous complaints, I know are not open because they are anonymous. But we just kind of try to make common sense about what has been sent into us and whether or not there's possibly we could actually substantiate the claim. Number 41, case number 2013000511. Here the complainant is a consumer who alleged that the respondent dealer sold her a motor vehicle and failed to provide a title. An investigation was conducted and found that the respondent dealer sold complainant a vehicle in April 2013, which was financed in-house, and failed to place title in the name of the complainant and provide registration. Further, the respondent admitted to employing a person not licensed as a salesperson and provided to the commission that the person assisting the vehicle in the sale to the complainant. I recommend authorization for a civil penalty in amount of $1,500, $1,000 for the deceptive act of failing to title and register the vehicle, and $500 for employing an unlicensed salesperson, to be settled by consent order or formal hearing. Number 42, case number 2013-008791. This was here a complainant consumer alleged that the respondent dealer sold her a salvaged vehicle on a salvage title and failed to disclose such at the time of sale. An investigation was conducted. The investigator found that the location did not have, when they walked in there, they did not have a landline phone. The investigator visited the location of the respondent, which was a sole proprietorship, individually owned, and asked for the owner from the employee who was sitting at the counter. The employee indicated that the ownership had changed to another individual owner. This information was not provided to the commission, and if being true, they would actually require a new license. The employee was asked to contact the owner, and the employee declined to do so. The investigator left the location, and the employee locked the gates, barring re-entrance. The investigator also found that the respondent's surety bond was canceled in 2012. The respondent failed to cease and desist from operating the dealership since that time. The investigator interviewed this supposed new owner, who we were not aware of at the time, who sold the vehicle to the complainant. This person is not licensed as a dealer or salesperson, and thus they're actually conducting unlicensed activity. The respondent admitted to providing the complainant with a salvage title, but insisted that she knew this type of title was being provided. The complainant provided a sworn statement that she was not aware she was obtaining a salvage title, and stated that she has been driving the vehicle for months, and the respondent knew she was currently driving this vehicle on the road. I recommend the authorization of revocation of the respondent's motor vehicle dealer license for fraudulent acts of selling a motor vehicle for operation without 15 months, employing a salesperson not licensed as such, and for unlicensed activity on part of this new owner.
Does this require a formal hearing?
It depends. If I send them the consent order and they sign it, then no, it won't require a formal hearing. If they don't, then yes, it would require a formal hearing, unless their license actually just expired.
What's an emergency situation?
Well, this was, I'm not sure. What's difficult is that it appears that this person has bought one salvage vehicle at the time, and we don't really know the level of activity that they're operating at. And even if the difficult fact here is that if somebody has sold this dealership, and there's somebody else who has taken it over as a sole proprietorship, they're actually conducting unlicensed activity, which means that the license at this point is almost null, other than the fact that they're utilizing the old license. Is that okay? Case number 201301163111. Here the complainant is a consumer who alleged that the respondent dealer engaged in deceptive acts of selling and repossessing a travel trailer sold to him. The complainant alleged that he purchased the vehicle in-house, financing, and for over 3 months could not obtain title and registration. An investigation was conducted. The complainant agreed to allow the respondent repossession of the vehicle. The respondent admitted that he did not have proof of ownership of the travel trailer that he sold to the complainant. This was when we investigated the complaint. The respondent indicated that it was purchased from an unknown person and did not have title or documentation showing any ownership. The respondent indicated that he had planned on providing the complainant a bill of sale on the travel trailer after he finished paying it off. The investigator who conducted the inspection of the dealership found that the respondent they failed to properly maintain a record of the issuance of their temporary tags. The respondent indicated that the travel trailer, that he did in fact repossess it. He sold it to his brother that was dismantled for parts. So we have a dealer who sold a vehicle who had no proof of ownership whatsoever. And then after he repossessed it, he sold it to somebody to be dismantled. And never had a temporary tag log. I recommend authorization for civil penalty in the amount of $1,500, $500 for selling the vehicle without proof of ownership, actually never maintaining proof of ownership, and $500 for failing. Excuse me, that should be, yes, and $500 for failing to maintain a temporary tag log, to be settled by consent order or formal hearing. Number 44, case number 20130125511. Here the complainant is a consumer who alleged that the respondent dealer engaged in deceptive acts and failing to disclose that a rebate was used in order to lower the price of the vehicle to come to agreed upon price. Investigation was conducted and found that all documentation was in favor of the dealer, indicating that the complainant understood the use of the rebate. The investigator indicated that there may have been a language barrier between the complainant and the respondent, which could have contributed to the confusion. I believe the complainant here, I think English was their second language. I recommend that we close this with a letter of instruction to the dealer indicating the importance of providing clear information as to how the rebate is applied to the customer. Number 45, case number 20130146661. Here the complainant is a consumer who alleged deceptive acts by respondent dealer regarding the type of warranties provided with the vehicle. The respondent provided a copy of buyer's guide indicating warranty covering any remaining factory warranty. At the time, there was part of a remaining factory warranty regarding emissions and corrosion. The complaint indicates that she was led to believe that this covered the powertrain transmission. Shortly after purchase, the vehicle's transmission failed. The factory warranty had expired. I recommend that we close this with no violation being found. The vehicle warranty included only those remaining factory warranties. Number 46, case number 20130156111. Here the complainant consumer alleged that respondent dealer engaged in bait and switch tactics. An investigation was conducted. The complainant had viewed an internet price advertisement on the vehicle by the respondent, and they viewed it on Sunday and they printed it off on Sunday. The complainant attempted to purchase the vehicle for that price on Monday via the telephone. The respondent refused to sell the vehicle at the previously advertised price due to a recent service work performed on the vehicle, and indicating that the vehicle's price had changed on their internet pricing. The respondent provided documentation to us from the people who maintain the internet site, which indicated that the price on the internet was increased by the third party, and it was uploaded to the internet on Sunday. As such, the respondent dealer actually had changed the price. I recommend that we close this, no violation being found. In case number 20130086601. Here the complainant consumer alleges that he bought a new motor vehicle from a respondent dealer that did not perform as advertised, and that the vehicle was deemed unsafe by NHTSA. If I showed you a picture of this vehicle, you would realize that this is kind of odd because it looks more like a three-wheeled vehicle. It has one wheel in the front, two wheels in the back. And their complaint was that it didn't get 65 miles per gallon. The investigation was conducted and found that the respondent, who does not hold a new motor vehicle dealer's license, sold a new motorcycle to the complainant. The MSO indicates that it's a motorcycle. The vehicle appears to be three-wheel, fully enclosed. The manufacturer is not licensed to distribute this product in the state of Tennessee. The MSO for the vehicle listed the respondent on the MSO as the receiving dealer. The NHTSA had placed a recall on the vehicle because it would not stop within the required distance for such vehicle. The vehicles are prohibited. Because of this, they're prohibited from operation on the roadway by the NHTSA. The respondent admitted to selling 5 of these 6 vehicles, but an exact number could not be obtained. It's not known the number of these vehicles that were sold in Tennessee, but they're no longer selling them anymore. I recommend an authorization for a civil penalty in an amount of $2,000 for this unlicensed activity to be settled by consent order or formal hearing. 48, case number 20130129161. And this case is, when we go through it, this is related to the case that we had last month, where we had a discussion as to what to do about this one. Here, the complainant is a dealer who alleged that a competitor, the respondent who is a dealer, engaged in deceptive acts by failing to conduct motor vehicle safety recalls and for allegedly falsifying pre-delivery inspections documentation they provided to the manufacturer. Investigation was conducted wherein the respondent provided an affidavit of a former employee who indicated he was fired for not signing backdated PDIs on vehicles he did not sell. A similar complaint is already opened against this respondent for these exact same allegations. This is just a new person submitting the complaint. The commission previously authorized for legal counsel to update the chairman on the Attorney General's pursuit of legal action. I recommend that we do the same thing. Request my office to keep the chairman informed of this case with developments with the Attorney General's office. And as of last week, the status is that they're still investigating the matter. 49, case number 20130119141, 20130119142. Here, the complainant consumer alleged that the respondent dealer and salesperson engaged in fraudulent acts and the salesperson engaged in unlicensed activity as a motor vehicle dealer regarding failure to pay off a trade-in vehicle. An investigation was conducted. The investigation found that the complainant purchased a BMW in 2011 from who will call this person Dealer 1, who is now out of business, but owned by the respondent salesperson. In 2012, the complainant alleged that he traded in the BMW to respondent for purchase of a Mercedes. The documentation indicates that the Mercedes was sold by an Arkansas dealer, which was solely owned by this respondent salesperson. However, the sale took place in Tennessee at the location of Dealer 1. So he's a salesperson at dealership in Tennessee. He owns a dealership in Arkansas. He takes a car from the Arkansas dealership and sells it on the Tennessee lot. Is basically what he did. The respondent salesperson attempted to sell the vehicle to a pre-planned purchaser, someone else, but that sale never took place. The BMW was never paid off. The complainant obtained a loan for the Mercedes, the new vehicle. The respondent salesperson then opened dealership 2 at the same location as, that should be Dealer 1. And the original traded-in BMW was sold to a Tennessee resident under the name of the previous Arkansas dealership that's purportedly sold this Mercedes to the complainant. This sale took place at the same location as Dealer 1. The BMW was never titled to the new owner. The new owner made payments to the complainant's original loan company, but defaulted and the vehicle was repossessed. So, maybe not to make it complicated, they traded in a vehicle. The dealer took the vehicle on trade-in, never paid off the lien, and then he sold the vehicle to another person. Lien still never paid off, and that person he sold it to made 3 or 4 payments to the original loan company, and then they stopped making payments and the vehicle was repossessed. Documentation appears to show that as part of the trade-in that they were going to pay off the lien. So and it was obvious that this dealer is taking vehicles from an Arkansas lot and selling them on his Tennessee lot, or when he's going to do a deal that doesn't seem to be really comply with the law, he does it through his Arkansas lot in Tennessee, using Tennessee residents as customers. So for that, I recommend the authorization for the revocation of his motor vehicle salesperson license for deceptive acts of unlicensed activity, acting as a dealer in Tennessee at a licensed location, and fraudulent acts. And the next case is actually the dealership. I recommend the authorization for the revocation of the motor vehicle dealer's license owned by the salesperson for fraudulent deceptive acts. It appears that this dealership in itself is probably just a shell corporation, basically, for him to sell his cars from Arkansas or wherever. But it's clear that this dealership is owned by the same person, and he keeps closing down a dealership, opening a dealership, closing down a dealership, opening a dealership in the same exact location.
Transactions coming across the state line, they're coming from the state of Arkansas, and
He's
they're
actually-
harming Tennessee consumers. Is that the,
Yeah, he's actually selling them at his, he's selling the vehicle at his Tennessee dealership, but he's using a bill of sale from the Arkansas dealership. So it appears that the vehicle was bought in Arkansas. And he's doing it on his Tennessee lot.
is there another authority that we could turn this over, since this is interstate commerce? Could this be a TBI matter, or even an FBI matter?
Maybe, I'm not so sure as to how far it would get investigated for them, because this is more of a deceptive acts type deal. And what they'll probably say is that there's a contract here with an Arkansas dealership, which I'm assuming is in business right now.
Are they habitually not paying the trade-ins off?
This is this is the only one that I've seen like this. This is the only one that I've seen like this, and it appeared that when he actually traded in this original vehicle, there was this agreement. We're gonna take this vehicle and we're gonna sell it to this guy, and we're gonna pay off the loan as soon as we sell it to this guy. Well, that guy never shows up, and the dealership has actually obtained this vehicle as a trade-in, and we're talking $48,000 vehicle with a really large lien. So
If there were an ongoing conspiracy to come in and trade for vehicles and resell them without paying them off, that would be more than a deceptive act. I think that'd be some type of,
I can
that'd be some kind
definitely
of theft.
I can definitely
I mean,
do
if
it.
it's one misunderstanding by an out-of-state dealer, I think this is appropriate, but if there's more to it than this,
That's not it's easily done. I can send a copy of the entire report to the Tennessee Bureau of Investigation for them. Probably Department of Safety also, so that they have it. Case number 201-2022711 and 201-2022711. I'll just caption this off by saying this appears to be a motor vehicle salesperson who's acting as a dealer. If we keep that in mind, maybe it'll be a little bit clearer. Here the complainant is a neighbor of Respondent 1 who's a motor vehicle salesperson, and he alleges that the salesperson is selling vehicles from his residence, basically acting as a dealer. An investigation was conducted. The investigation found that this salesperson purchased 4 vehicles from auction or private sellers using personal funds through a licensed motor vehicle dealer for which he did not hold a salesperson's license for. So he bought them from an auction, he didn't have a license. And he subsequently sold those vehicles through this dealership, but he's not a salesperson for this dealership. This dealership is now out of business. It doesn't have a license anymore. Respondent 1 then obtained a motor vehicle salesperson license from Respondent 2, an actual dealership, and he purchased 5 motor vehicles from auction or private sellers, and he purchased these vehicles with his own personal funds through this dealership. And then the documents we obtained indicated that the vehicles were purchased through this dealership and actually sold through this dealership. So he's using his personal funds at auction to buy vehicles through a dealership, and then he's turning around and selling them, it appears to be through the dealership at the same time. The The investigator obtained affidavits from 2 persons who indicated that they in fact purchased the vehicles from his actual residence, not from the dealership. Respondent 2's dealership records indicates that it's accepting personal payments from Respondent 1 from the sale of vehicles. So this, from what I see time to time, is where somebody receives a salesperson's license from a dealership. They're not employed by the dealership. They're an independent contractor. They buy vehicles with their own personal funds. The auction documents show that it's bought through this dealership. Then they turn around and sell it, usually list them on eBay. I think these were listed on Craigslist, and they sell it using the dealership's bill of sale. And then once they sell a vehicle, they pay the dealership a certain amount of money to be able to sell the vehicle through the dealership. In my analysis, this is actually unlicensed activity as a motor vehicle dealer because the
Auctions that are taking personal funds seems
And
like a
waive the
problem
sale
to me
tax,
as
too.
well.
Right, what generally happens is that they have this separate account that they use, a checking account. It has their name on it. It may say like car fund or something like that. It has something on there. And this is what they use to purchase these vehicles with.
Seem those would be matched up, though, with the auctions records and the primary account for buying cars versus this one on the. I think there's some negligence on the part of whoever these auctions are. It might be out-of-state auctions, but some negligence there on the part of the auctions.
I think these were here, and I didn't actually, the fact of which actual count is utilized at auction is a little bit difficult for me to determine because I don't know. I have a copy of the check. I can see which check it was written out at, but what I don't have is what is the exact account that they're required to use at auction and whether or not they're using that account. That I don't know. I guess the focusing fact that we're looking at is that, one, the salesperson is not employed by the dealership. There's no W-4 that he's getting paid off of this or a 1099 or something like that. He's using his personal funds, and the salesperson admits, I use my personal funds to do this. Then again, he says, I've been a dealer for 30 years, and this is how it's done, and I can do this, which I don't believe is correct. And he was in fact selling these vehicles at his residence. We know this from two affidavits that this is what he's doing. So
Could we at least send a letter of warning to the auctions?
we can. I would like to. I'm trying to think as to what the auction violations. I'm not sure if this captions under allowing an unauthorized person in auction.
Make a friendly phone call then?
We can. I do have correspondence with some of their legal counsels, and I can ask them the question as to how they authorize or maintain accounts and how these accounts are paid through, and just show them this information and open a dialogue. How's that? I can get more information, basically, is what I do. So if we want to add here for
Communication
yeah,
with
right.
the
Yeah, that's all I
auctions.
add is communicate.
If you can find out if you can determine which auctions they are, they might be out of state again.
I have the auction documents.
Okay.
From my understanding of the file, I believe they were here in the Nashville area, but this is where the salesperson lives. I'll communicate with their auction counsel account authorizations. And I recommended a civil penalty against the salesperson for the amount of $4,500, which that would be $500 per 9 vehicles of unlicensed activity. Captioning is, I believe he's acting as a motor vehicle dealer in this capacity. And then authorizations for a civil penalty in amount of $2,000 against the actual dealership for failing to employ its licensed salesperson and for failing to reasonably supervise this conduct of off-site sales for vehicles that were bought through the dealership. Number 51, these are now representations. We have just a few representations. The first one, number 51, is case number 2013002721. At the July meeting, the commission authorized a $3,500 civil penalty against this respondent dealer for altering temporary tags and committing deceptive acts. The respondent's dealership license actually expired The respondent cannot be contacted. This office previously forwarded the entire complaint to the Department of Revenue for possible tax violations. Since we can't find this respondent, I recommend that we close and flag with referral, with the previous referral to the Tennessee Department of Revenue, since this dealership is closed. Number 52, this is 3 cases. Case number 661-2013-007-231-20. At its April meeting, the commission assessed civil penalties. They were either between $250 and $500 against these respondents. They were all minor infractions, and again, like the previous one, these respondents' licenses have expired and they're no longer in business. We cannot I cannot notify these respondents of the violation since all their mail is returned to our office. I recommend that we close and flag these. And I need to make an amendment. I need to take out respondent surrendered its motor vehicle dealer's license, please. 53, case number 20130033581. This is probably the only time we're ever going to see this. The commission previously authorized a $2,000 civil penalty against a respondent dealer for failing to provide conditional delivery agreements. I had made an error and had talked with their legal counsel and agreed to $4,000. And when I sent out the consent order, we sent out $4,000 and they paid it. So they have paid over what the commission authorized, but I gave you the wrong amount. It should have been $4,000. So we need to increase that authorization. Number 54, case number 2013011-091. Here, this respondent, the above complaint, this is one complaint received. We received this stating that respondent's dealers failed to provide titles of registration. The dealer has abandoned his business and is no longer operating. We did send the surety bond information. I recommend that we close and flag. Respondent is out of business. And for number 55, these are cases 20130086661, 2013013, 201301641, 20130153111, 201300647, 20130100471, and 20130. All of these complaints were received stating that respondent dealers failed to provide titles and registration. I recommend that we close these cases. Number 56, 2013-008871, 2013-01301231. All of these complaints were submitted, and after they were submitted, the issues were settled between the parties. I recommend that we close these, settled between the parties. And number 57, these 4 cases, which I won't read their numbers, those 4 cases were after we received the complaint. Their complainants withdrew the complaints. Recommend we close those, withdrawn. And the last case, number 20130076681. This is a first offense advertising violation from the dealer during this year period, and I recommend that we close this with a letter of warning.
Just for verification, when a dealer has gone out of business and we find them and we can't find them, and you know, we close and flag it, have we had any dealer to come back and try to open up another dealership? Okay.
Not that I'm kind
Would
of
they have
looking to
to pay that
Leon and
fine?
Jason near me, and I don't generally see it, no.
Okay. Would they have to pay that fine before they are granted another license, dealer license?
It's not in the statute for that. It's not in the statute that they would have to pay the fine. What we would do is we would, they would apply for a new license. They would probably get this new license, and then we would hand them the consent order to be paid also at the same time. Not in the fine. But no, they're generally gone, and we don't see them again.
Questions? There being none, so.
Right. We'll convene the regular meeting of Tennessee Motor Vehicle Commission at after 10. We will ask Executive Director Leon Stribling to have a roll call.
Commissioner Billy Keck. Commissioner Lynn Webb.
Here.
Commissioner Sarah Vaughn.
Here.
Commissioner Don Parr.
Here.
Commissioner Mark Parr. Here. Commissioner Reed Trickett.
Here.
Commissioner John Murray. Commissioner Nate Jackson. Here. Commissioner Donnie Hatcher.
Here.
Commissioner Joe Clayton. Commissioner George Bass.
Here.
Commissioner Stan McNabb.
Here. Thank you. Okay, you should have the minutes from the last meeting. If you would, each of the commissioners would look at those and either approve or revise those minutes. With that, I'm going to step down for just a second for an errand in the audience. Comments on the minutes from the last meeting?
Make a motion to approve.
Have a motion to approve by Commissioner Cullum,
Second.
second by Commissioner Vaughn. All those in favor, say aye.
Aye.
All opposed, say no. Motion carries. We need to adopt the agenda for this meeting. If you'll quickly review that if you haven't already. A motion to adopt the agenda. Commissioner Trickett moves.
Second.
Seconded by Commissioner Bass. All those in favor of the motion, say aye.
Aye.
Opposed, would say no. Our agenda is adopted. We'll be looking at our calendar for our motor vehicle commission meetings during the year 2014. Have we circularized those? If you'd look at those, see if there are any, that's a wrong, comments are wrong. Could we look at those for adoption? Better be more positive. We need to read those dates into the record.
I think that'd be proper, Mr. Chairman. Department or I, either one, can do when the attorney for the defendant continuance and is granted, and that's when I have to advise you all at a late date.
Let's read those dates into the record.
2014, these will be the scheduled meeting dates. January the 6th and 7th, March the 3rd, April the 21st and 22nd,
July the 14th and 15th, September the 8th, October the 6th and 7th.
There be a motion to adopt the calendar for 2014?
Second it.
Didn't get the first. Was it Commissioner Pearl? And Commissioner Bass seconded? I'm sorry, Commissioner Jackson, excuse me. All those in favor, say aye.
Aye.
Those opposed, say no. Okay, the calendar's set for 2014. Thank you. We are ready to move into the salesperson's applicants' appeals. So the first one that we'd like to hear from is Dan Cox, Kia of Johnson City, Elizabethtown, Tennessee. Cox, if you just take the, well, that thing is actually turned around backward. Where would we, you want to turn that around? Will that work? Or you want to, there we go. Let's see if your mic seems to be working. When you're speaking, that red light will be on, Mr. Cox. So first, let us hear from the staff as to why the application was denied.
Of the felony of aggravated burglary, and the 5 years since the end of probation or end of sentence occurs September the 17th, 2016. So the
September 17th, 2016. Okay. Mr. Cox, you know why your application was denied. We have a statute that kicks in automatically, and that can be appealed by the commission. So you're here today to assume to request that the commission make an exception. So if you'll tell us why you feel like we should, we'll be glad to listen.
I was sentenced in '99 at a young age. I was supposed to got off earlier than 2011, but where I violated probation, it extended out to 2011 off of parole. I've been out of prison right now 3 years and off of parole for 2 years. I'm just trying to be a positive member of society instead of someone who's always getting in trouble.
Currently employed? Okay, where do you work, sir?
Of Johnson City.
What are you doing there?
I'm a detail manager.
Okay. Commissioners, any questions for Mr. Cox?
Conviction for?
2 counts of burglary, theft over 1,000, and 7 counts of forgery. It was all ran together under one sentencing.
Are these residential burglaries? Okay. Checks, what did you write the checks for?
On my mom and dad's checking account, Dad knew about it, but Mom didn't know about it. So when I went to jail for the 2 burglaries, the bank contacted my mom, and my mom didn't know anything about it. So she then again said it was forgery.
What did you buy with the checks?
Cigarettes, beer, stereo equipment, speakers.
There was a parole violation. What was that?
It was a probation violation.
Probation, okay.
2006. And then when I went before the judge, he went ahead and sentenced me to prison. I got out in 2007, and there was a violation for dirty drug screen, which when I went back to jail, they tested me again. I was clean, but where the judge already sentenced me to serve a year before I seen the parole board again, I had to do a 1.5 years. So they let me out 2010, and I completed in 2011.
Questions or a motion?
No question.
Commissioner,
Working for Grindstaff Key in Elizabeth, or Grindstaff Chevrolet in 2004, they denied me then, and they terminated my employment there, and that's when I moved to West Virginia, and I hadn't applied since until now. Told me they just said I was denied for a license.
One here from Kia, Johnson City. You have any representative here?
Right forward, sir. Hi. Identify yourself.
Michael Driver.
And what's your position at Kia?
I'm the internet manager there.
Who's your sales manager there?
Sean Brown. I've been in business 13 years. I was owner and manager at the Rusty Wallace Kia in Alcoa for 6 years, and then moved up to Kingsport and kind of semi-retired, I guess. I offered to bring Dan here today because I believe everybody needs an opportunity to do better. It impressed me that when he came, he got his license turned down. He just didn't go out here and not do anything. He was wanting to go back and wash cars, and has been doing that for some time. And I just feel like that he's on the right road. I know that he goes to church now pretty regularly. His father-in-law's a minister. I'm an ordained minister myself. And so I just told Dan today, I said, Dan, whatever happens, I mean, it's up to God may have something else for you to do, but you're not going to know until you go and appeal to these men and see what they feel like. I knew everything that he shared with you today. He shared with me before. He's never, lied to me about anything, and he's doing a good job in the detail department. But he wants to be in sales, and so I offered to come up here at my expense to bring him up here. We left Kingsport this morning at about 5:30, and drove here to appeal to you guys to give him an opportunity, and so that's why I'm here with him.
How long have you known him?
I've known Dan about 6 months.
You don't supervise Mr. Cox. You're not a supervisor.
Well, I do and I don't.
What does that mean?
Well, I'm in a management position. I step forward anytime that something needs to be done, to help out with the management team. I do turns for him on the lot, and I actually sell some as well myself. But I could have come here and said, oh, I'm a supervisor, but I'm not that type of person. I'm not going to tell you that I'm not. But I do supervise, I'm not just a normal salesperson. I guess because of my management background and I was a partner at the Rusty Wallace Kia with Rusty Wallace. I owned part of the dealership there with him before I decided to move up to Kingsport in January, and I was with him for 6 years. And so I've got quite a bit of management experience, but I try to help the guys out. I see it more my mission in life now to be an influence coming into the industry to help, help them, because I'm amazed myself at the number of folks, young people that are coming in that's got drug problems or past, prison time and all that. It's unbelievable to me. And so somebody's got to help guide them. And that's really why I'm probably there more than I'm definitely not there for the money.
I might have missed this, but the 2006 parole violation, what was that violation, Mr. Cox?
Dirty drug test.
Bob, or that's a condition of your parole, is drug testing?
Back to 2004, and you said you were denied, and you didn't really know why you were denied. When you filed your application, where it says, have you ever been convicted of a felony, how did you answer that on your application in 2004? Huh?
I answered yes.
Okay. So that's why they denied you? Okay.
It was the dealership, they just come back and said,
Okay.
Have a motion either way for this.
Motion we approve is his request.
We have a motion to approve the application by Commissioner Trickett and seconded by Commissioner Pearl. Discussion of the motion. Hearing no discussion, we'll call for roll call vote.
Yes vote will be to grant Mr. Cox the license. Commissioner Parr,
Yes.
Commissioner Purtle,
Yes.
Commissioner Cullum,
No.
Trickett,
Yes.
Commissioner Bass,
No.
Commissioner Vaughn,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Webb,
Yes.
Commissioner Jackson,
Yes.
Chairman Roberts.
No.
Chairman, you have 6 yes, 3 no's.
Cox, your license will be approved. Get back in touch with the staff and you'll be,
Thank you for your time.
congratulations. Cecil Ray Davis, Chuck Graves Chevrolet, Humboldt, Tennessee.
Chairman, Commissioners of the Board, thank you for allowing me to come up here and speak with y'all today.
You are Mr. Davis.
I am Cecil Ray Davis, yes, sir.
Welcome, Mr. Davis. Hear from the staff, please, for the reason for denial of the application.
This was a conviction of a felony mail fraud. End of sentence, July the 2nd, 2012. 5 is July the 2nd, 2015.
July the 2nd, 2015,
2nd, 2017 will be the end of.
17, excuse me.
Right.
July 2nd, 2017.
They got me, we got somebody's name back at the dealership. It was Cecil something else Davis. My term was from October the 7th when I entered prison, and I was released on the 12th of November. November the 22nd of 12, I finished my term.
Finished it when now?
November the 22nd of 12, my term ended. I have a letter from my probation officer stating that time. It's some kind of, we should have maybe called back and straightened that out because
Well, we've got the year correct at 2017.
Record.
The 5 years would be up 2017, as
That's
stated by
correct.
the staff. The only part of that's in question is,
oh,
it's-
that's when the 5 years after you're out. Is that, oh, I misunderstood you. I'm sorry.
5 years, it's 5 years after your probation is up or your sentence is served. And so your 5 years would be 2017. So what was the conviction for, Mr. Davis?
2 counts of mail fraud, $10,000 one and a $20,000. Was a businessman, been a businessman 40-something years, and they mail fraud in my business.
Business.
My business was I owned a marketing company that marketed vending machines, the medication machines you put out in like Nissan and all the big corporations that they sell, you know, your aspirins and, you know, over-the-drug, you know, medication. And I owned an import business that imported high-level furniture and pottery for upper-end furniture stores like Bradford Showroom and stuff like that.
Nature of this mail fraud, what were you what were you collecting?
I borrowed money from individuals, and the loan was to me personally, and the party said that I did not specifically say which company I was putting that money in, whether it was in the marketing business or was it in the import business. So technically, that's what they got me, because two people out of some that I'd done business with, that I did not tell them exactly where I was putting that money, which company. And like I say, when you're a businessman, when you are in the community, and and something like this happens, it's a devastating to your family and you, and so you just kind of fold your wings in, and you fight them as long as you can, but after a while, you just it's
This is 40 years, but you felt the necessity, or you were in a
Well, this
financial
is,
situation where you were borrowing money from.
you can't borrow enough money from the banks to bring in all the furniture and stuff that you need to borrow, because there's no way they can keep their hands on it. But had no problem with people, even the two on the 2 counts of mail fraud. It just
That dealt with the furniture part of your business.
mahogany, wicker from the Philippines, sold it to the stores and stuff. I don't want to get into politics, but I happen to be one party, and the U.S. prosecutor happened to be in another party at that time. And I hadn't been a legislator in 20 years, but that has a lot of say-so on your situation. I'm sorry. I mean, it's brought devastation to my family, and the only thing I'm seeking is a license to be able to sell. My wife she had viral pneumonia in '88, and she's in and out of the hospital 3 or 4 times a year. And while we have insurance, costs that the insurance doesn't pay and stuff, I just need to make a living, and I think car sales is a good opportunity for me. I would appreciate anything you can do for me.
Questions for Mr. Davis?
I'm still trying to, now walk that again, though. When you were borrowing money from a bank, you own two?
Never borrowed, no.
Okay.
I borrowed, yeah. I was in good shape with my banks. Just when you import like thousands of dollars of furniture, the banks cannot have their hands on it from when you start, So I would borrow extra money from people to bring in, the goods, and I'd sold them, and I paid them all back. I mean, nobody had any problems with me, paying them back. It's just, I might have made somebody a little angry long back, when I was a legislator. So that's the only thing I can think of. The U.S. prosecutor that prosecuted me said that he really hadn't done anything but borrowed, money, and I probably borrowed more money than I could pay back in 30 days. That's basically what it boiled down to. But I'm not blaming anybody. I'm not saying anything. I mean, I accept the situation. It's like I say, it's devastated your family. It's something you never hope anybody that has to go through or anything. But you get through it, and you try to become a productive citizen again. That's what I want to do.
So nobody lost any money, and you were sentenced to 57 months?
Oh, yeah, they did when they came in. People lost money because I couldn't pay them back, because they virtually shut you down when they come in. Basically what happened,
How much money did they lose?
Well, the total was, I got convicted on 2 counts of mail fraud, $10,000 and $20,000, but the sum of money was $2.5 million or $2.2 million that I had borrowed at that time. And I was paying people, but, I borrowed more money than I could pay back in a given time period.
You call this, or would you describe this as a pyramid?
Oh, sir, they didn't do that either. No, it wasn't a pyramid. I had the furniture, I had the stuff. I mean, it was just, sometimes it was costing more than I expected, and like I say, I couldn't. No, it wasn't a pyramid. I just borrowed more money than I could pay back at a given time.
2.5 million were from consumers, not banks, or did that include bank loans?
Oh, it was from a few, you know,
Did this with a mail flyer, a flyer of some type?
no. They
How'd-
just,
how'd
you
you-
know, mail fraud, they can just get you if you send them payments like I did out.
How'd you make contact to raise the 2.5
Oh,
million?
I didn't have to. People came, you know, they come to me, you know, and asked me, you know, if I could, you know, if I needed any money, you know, to borrow money, or loan me money. You know, I had a good record. You know, I was paying people back. You know,
Which return were they getting on their 20%? Oh,
all right. I mean, you make about
would you say that one end of this, people got paid back pretty quickly with a good return? 20% sounds like a good return.
That was a
to me.
year. I mean, I done it a year's time. It didn't change. I mean, it's still on a year. I mean, year's time.
This solicitation was done from personal contact?
But the total losses were over 2 million, is that? Okay.
Pay every month. You know.
Fellow commissioners, there are a lot of these mechanisms out there for being fair as possible, Mr. Davis. We see these, and our industry tries hard to not become victims of these, and not have consumers become victims of these. We see them in all types of. I'm troubled by this. I think as much effort as our law enforcement people put into schemes of, and this sounds like a scheme to me, into what I think is a scheme, I think we'd be very inconsistent to grant a license to someone involved in such activities when we're trying so hard to discourage these things. I think we all get the letters from out of the country for different things. I'm not talking about foreign goods, and let me let I'll give you another turn. I sure will. Any commissioners?
I'm still trying to deal with the mail fraud, and if even if you don't pay me back, I mean, that's what's confusing to me. I'm still trying to figure out, it's my money, I can give to whoever I want to, but then you get charged with mail fraud. So did I send you the check in the mail?
We might ask our counsel to enlighten us on mail fraud, but in my I'm not this is not legal interpretation, but mail fraud is kind of a catch-all, I think, for activity that fairly commonplace. Counsel.
I do not have the statutory definition of what the federal mail fraud count is.
Comment.
I ran my business, the same business I ran for over 20 years. Down Swain, and as I bought stuff, you know, it didn't bring enough money in to pay people. but yes, I did pay them, but I paid them slow. None of the people, I had one person in New York that was a friend of a guy there in Milan. He loaned me $20,000. That's it. And I did not tell him that I was putting it into my export business, you know, or I didn't tell him I was putting it in my marketing business of the vending machines. And he answered the question. He did not. All I can tell you is, yeah, I made a mistake, but no, it wasn't pyramid. Stuff came in, I sold it out. I marketed machines that we had. You know, I ran never had any trouble with the law or anything like that.
Made a reference to political office. Were you in political office while this was going
State
on?
legislator for 14 years in Gibson County.
And this activity went on during,
They didn't. 04, I'd been out of office since 1992.
occurred in 04. But you did have a lot of networking and a lot of public trust, having been a public official. Maybe more than.
I did everything I said I would do. I think that's why money, it just came, a slow period there. You know, I don't handle any kind of money. I don't do anything. Car dealership, I have not gave any trouble. I am doing my sorry for what happened. I just, like an opportunity to be able to just make a living where I can support my family. My wife's in the hospital 3 or 4 times a year. It's a tremendous pneumonia in '88, and it just devastated her lungs. It devastated her heart. She has to come to Vanderbilt, and I just.
During the productive years of your business, what was your average income from your business?
Probably somewhere around $1 million a year, something like that.
Approximately, was this over a 4, 5, 6, 7 year period? $1 million over a 10-year period each year?
I only made a modest, I didn't make a big living out of it.
Amount on here, it says restitution, and the amount is $10,398,000. Excuse me, $10,398,340.
Right, that's the restitution. 2.2 was what that meant what they did. They went back and they took every dime I borrowed from people, whether I'd paid them back most of it, half of it, or whatever. They took every dollar I'd borrowed, plus every vending machine I sold. If I'd sold you $10,000 worth of vending machines, and you had made your $10,000 back plus $2,000 profit, they'd still charge that against me because of the time period of, you misrepresented where you was putting the money. So, that's how that $10 million come about. Well, you fight them, and your lawyer says, you make a deal with them, you sign this, I can't justify, I could have fought them. I didn't have the money to fight the U.S. prosecutor, but.
Don't have someone from the dealership with you? Okay, you do. Okay. Would you like to speak, sir?
I'm Chuck Graves, the dealer. Ray started working for us a few months ago. We applied for the salesman's license. It was turned down, and we are asked for some more stuff in, and we did submit the rest of the stuff, and it was turned down again. We appealed it. All I can say is, since Ray's been working for us, he's been under training. We wouldn't let him sell cars, but he's working with the salesmen and working with the managers, and he's done a good job. a lot of people in the community have come in, seen him. You know, I don't know if anybody that he owes money to has been in, but a lot of people have come in and love him, and you know, I think he does deserve a chance. I mean, we're a small dealership that we watch everything very, very closely. I know that we have a good name in the Madison-Gibson County area, and you know, before Ray, before he was turned down his license, he sold a couple cars, and he was very good with customers. Customers liked him, and you know, we feel that he could do us a good job, and we can do him a good job. I mean, if he is going to go to work someplace, I think that a small dealership where we watch every deal, we work every car deal, you know, very closely. I'm there about 6 days a week, unless I'm out chasing my children someplace. And you know, it's a place that is family. My mom's still working there, and we've been there since 1980. So if he is going to be in the car business, I think this is a good place for him to be at.
Your comment regarding no one that he owes money to has been in your dealership.
I mean, what I've seen is I've seen people come in. Last week, this lady come in. We sold her a car. Saw Ray. You know, I didn't know he was here. Give him a big hug. They talked, and there's been a lot of people come in and talk to him. Now, you know, I haven't seen anybody come in, walk up and say, "You dirty," you know, whatever the case may be. That hasn't happened.
All right, to put this in a perspective that I see, and I'm sure Mr. Davis has friends and supporters. Obviously, you're one. You know, we're hearing from this side of the equation. Now, is there anyone out there who lost money in this, what I think is a shell game, who says he should be granted a license? Personally, I don't think so.
I've not, well, there again, I have had no comment, no phone calls, no comments to the point of I can't believe he's working there or anything of that nature. And I am the dealer, and like I said, I'm there a lot. So I've had nobody call and say, why did you let this man go to work for you? I mean, it's, you know, he's well known.
I'm not worried about your phone calls, I'm worried about mine.
I got you. Yeah, I would think they would call me first, you know, and I
Might call me if he's granted a license.
I'm hearing some of the stuff that you're hearing a little bit for the first time, and I kind of get it, but I still think that he, you know, everybody deserves a second chance. If you grant it with us, we'll make sure that he does it right.
Thank you, Mr. Gray.
Mr. Chairman,
Yes, sir, Mr. Pearl.
in respect to your previous comments, I agree 100%. I think all communities in Tennessee of any size have been involved in Ponzi schemes. Murfreesboro was certainly involved in a very large one in '07 and brought in our university and really hurt a lot of good people. People that were at their end of their careers and had their life savings with this man that committed this fraud. There was one in Dixon, Tennessee, one in Brentwood and Murfreesboro, but I mean, they're basically happening in many communities. For us to try to uphold the reputation of this commission and our industry, for us to approve a license for someone who's just released from prison last November and committed this size of a fraud. You only pay 20% when you're desperate, and we all know that. All of us are involved in one way or another in banking, and we know the prime rate is 3.25. So with this type of action and the judgment or the restitution being $10 million, I really believe that the U.S. prosecutor took this very seriously, and I would vote to deny this license at this time. A motion, I'm
That's a
sorry,
motion.
yes, sir.
We have a motion to deny the license. Yes. Discussion of this motion. Okay. Director Stribling, if we vote for the motion, the license is denied. Is that the way that's phrased?
Yes, sir.
Yes means the license, the staff denial will be upheld. And roll call, I'll call for roll call vote, hearing no more discussion.
Yes vote will be. Barr,
Yes.
Commissioner Purtle,
Yes.
Commissioner Cullum,
Yes.
Commissioner Trickett,
Yes.
Commissioner Bass, Commissioner Vaughn,
Abstain.
Commissioner Webb,
Yes.
Commissioner Jackson,
Yes.
Davis, regret to inform you that the staff denial has been upheld.
I appreciate your time, though. I thank you very much.
Christopher L. Looper, Rainbow Ford LLC, La Follette, Tennessee. Welcome, Mr. Looper. Yes. Welcome to the commission. Would we read for the record the reason for the staff denial of the application for salesperson's license?
Cooper's conviction was a felony conviction for identity theft. Sentence ended November the 18th, 2012, November the 18th, 2000.
I'm sure we have some descriptions here of the offense, but tell us your version of the offense, Mr. Looper, if you would, please, sir.
Well, basically, I was convicted in 2003 on a offense that's in 2002 on a gentleman that we was going to go into business together, and I didn't. But I did sign his name to some documents, and I pleaded, and I got a felony. Basically, my lawyer, I didn't really know I was getting a felony until basically I was in front of the judge, but I sort of about passed out, and he said, you know, you can do this. And so I got put on probation, but I got 3 years probation. But because I didn't pay my restitution in time, and it was probably $10,000, $11,000, I was on a minimum of $100. Sometimes I had the money to pay more. Sometimes I didn't. I actually had to go back in front of the judge in Putnam County and get extended. He extended me the first time for 2 years. I still owed some more. He gave me 1 more year. And so that actually put me to 2009. Okay. Well, basically, I was still paying on it, and I got a phone call about this time last year, somewhere between October and November, that the judge finally, and there's a copy in there of where he finally, Judge Patterson, ended up, I sold him a car because I'm in the car business for a while. But actually, he had finally, I got a phone call from his state probation officer, I guess, said that Mr. Looper, you was free and clear, you know, blah, blah, blah. Basically, I just had my time extended, but I was originally only gave 3 years from 06. But they finally processed it or whatever last year about November, and that's when the judge signed
Your
off.
time is for restitution?
Yeah, all I have is 3
Your
years.
extension was for restitution.
I got extended to pay my restitution because, and I was just reporting about once every 6 months, but I was paying Putnam County clerk's office just some money. I got extended and stuff because I hadn't paid all my restitution. That was what happened. If I'd have paid it in the first 3 years or any time, then after 06, after I served my 3 years probation period, I'd have been just totally free and clear, but I hadn't paid all the money. That's all.
Probation ended this past year?
I was sentenced, I forget the month exactly, in 03. I think it's October, maybe in November of 03.
You have it on the application.
November.
Because what they'd done, they continued it about I originally was supposed to go to court like in March or something. I mean, 03's been a long time, it's 10 years ago. I think I was supposed to go in court like March, you know, and you go there and they extend it out and the judge goes on vacation. Basically, it ended up being like November when I finally went back. And then I was supposed to got off probation like November of that year, so they actually have to violate you so you can go back in front because I haven't paid my restitution. And the judge said, you know, I can only go out 2 years the first time, And I said, I'll try to have it paid. And he said, well, if you don't, Mr. Looper, you got to come back in here. But you need to pay this. Just stay in contact with your probation officer, which at that time I was on once every 3 months. Then they ended up giving me once every 6 months. And I hadn't even talked to nobody in probably a year and a half. And a lady called me last year and told me that I was able to go on vacation or wherever I wanted to go without calling somebody, which, to be honest with you, probably a couple years before that I hadn't, because I had paid it all. And I'd kept all my documents where I'd paid everything, so.
Questions from the commission members. Commissioner Bass.
Have you ever been denied a license before?
Not until this year, sir. In fact, I've still got 2 that would, because of where I'd left. I went through a divorce. Where I left, it would still be valid as of today, but.
Not until this year.
Yes, sir.
But on your application, you said, yes, you've been denied a license before.
Well, because I actually applied, we misunderstood in July when I was denied in like March or whatever. I was supposed to be in here in July, but my comptroller lady, she just read the paper and she said that it's going to come in front of you guys in July. We didn't know we were supposed to appear, so I was waiting like 6 weeks, and I called down here in September and they told me I missed so I had to reapply to you folks, and I did put on there I was denied, because technically I was just denied in March. I mean, I didn't want to lie to you, so. I applied twice this year, once in spring or wintertime.
Recollection at Director Scribner.
Yes, sir. What Mr. Looper's telling you is that the staff denied him.
I called somebody in August or September, and they said I got to do the process again. I had to turn back in my paperwork, send back in this stuff that we had, and get denied again in order to come down here today. So I actually applied twice this year, but I've never been denied until this year.
Been in the car business since 2004.
It's either December of '04 or December of '03, yes, sir. I went to work the last week of Christmas, and I think it was '04, yes, sir.
What's your job responsibilities or duties?
Well, I've been denied, I just been helping with detail and helping the owner and doing like lot boys and.
Since 2004.
No. I've been in sales, and actually I've been a closer before. I've been an internet manager. I mean, at first I was just a car salesman, but after 10 years you sort of move up through the ranks. But I have worked for several dealerships, never been denied before. But right now since all this, they just sort of put everything on hold. So I'm working for the owner. We're just a small dealer. I mean, it's the smallest one I ever worked at, but he's a great guy. My wife's employed there, so I'm just employed there, So.
Restitution is paid in full.
Yes, sir. I think there may be like a couple $100 here and there I'd heard about, but yeah, my restitution's paid.
What type of documents did you forge the signature on?
Well, I grew up in music. My dad was a pastor growing up, and we played bluegrass, and my son-in-law's a big bluegrass player. It's over here at the Opry every night. And I was at these little indoor flea markets. I had a couple of inside music stores set up that I was making a little money on the side. And this gentleman was sort of a rocker, and I'd met him, and he wanted to be involved, and I thought about it and whatever. And he gave me a Social Security number. And we went out and I actually got credit cards made with his initial and mine. His name was Russ. My name was Chris. It's called R&C Musical. He's going to open one in the town where he is from, about 50 miles from us. I basically didn't do it, and I'd bought some stuff. And then with that card, it was an open American Express card. And about that time, if you'd have paid it like every 30 days, you got no interest. And that's how I was running my other ones. So I'd actually, and that was around Christmas times, but I'd purchase a flat screen. It's musical instruments. Flat screen for my personal use. It's musical instruments. A trailer big enough to haul 2 4-wheelers I had. So it ran up about $7,000. Then you got all these fees that the state.
Credit card application or the credit card itself that you signed? The part that was the identity theft conviction.
Well, at that time, right. Mm-hmm. I signed his name. He gave me a social. I've never been in car business in my life. I was not ever getting anybody's. I mean, I worked at Lowe's in the paint thing. I never took nobody's Social Security numbers for anything. And and I peddled music on the side and played music at church. And so he gave me his thing, and basically that relationship with me and him, when I told him I didn't want to do it, went south, and he came after me. But I did do wrong at that time, yes. I shouldn't have signed his name, but we was going to go in business together, so.
So you had to reapply for a salesman's license most recently because you changed stores, right?
Yeah, I went through a divorce last year. I was married to a lady for 20-something years, and her mother's real sick, and basically the last 2 years we just didn't really live together. Anyway, long story short, I went through a divorce, left the car business. I was working at Oak Ridge Nissan, didn't really do anything for about 3 or 4 months, just sort of got remarried, tried to, sort of figure out what to do. And walked into this dealership where my wife's grandfather was in the hospital just down the road from. He's bought several cars from him. She was from that area, just a little small place. And so I got talking to the owner, and he said, "Hey, I'd like to have you." And so,
You had a license at Oak Ridge Nissan.
yes, I've had a license at every place I've ever worked at. Yes, sir. Never had an issue at all being denied. In fact, I've got a copy of them here.
Okay. Further questions or a motion?
You have someone with you?
The sales manager, my supervisor.
Welcome to and you are, sir?
John Wrinkle.
You might want to step up to the mic if you don't mind.
My name is John Wrinkle. I'm General Sales Manager.
Okay. Mr. Looper's presentation of his past employment, is that accurate as far as you know? Okay.
Working detail for us right now, but his wife is selling cars, does an excellent job. I know for a fact they're both in church. We're a small dealership. I've got 4 salespeople. All my people are in church. We're a strong Christian base, so. Chris will do right or he'll be gone. I don't play around.
How long have you known him, sir?
6 months.
Further questions?
Make a motion, we grant his license.
Second.
Okay, we have a motion, Commissioner Cullum, to grant the license, and seconded by Commissioner Trickett. Any discussion of the motion? Hearing none, I call for a roll call vote.
A yes vote will be to grant the license to Mr. Looper. Roberts? Commissioner Jackson? Yes. Commissioner Webb?
No.
Mr. Vaughn?
No.
Commissioner Bass? Commissioner Trickett?
Yes.
Commissioner Cullum?
Yes.
Commissioner Purtle?
Yes.
Commissioner Parr?
Yes.
Mr. Chairman, you have a majority yes.
Looper, you'll be granted a license to sell vehicles and need to get back in contact with the staff. Darrell A. Myers, Gary Matthews, VW, Kia. Darrell A. Myers. Last call for Mr. Myers. Questions for the legal staff? Discussion.
Second.
I don't know who I heard first, but I'll go with Commissioner Vaughn was the second on that. Commissioner Jackson made the motion. Structure of this for us is your motion to deny, so you voting for the motion denies. Yes, denies the application, upholds the staff process. Roll call, please.
Yes vote will be to
Hold the denial.
uphold the staff denial.
Correct.
Commissioner Parr?
Yes.
Commissioner Purtle?
Yes.
Commissioner Cullum?
Yes.
Cricket?
Yes.
Commissioner Bass,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Webb,
Yes.
Commissioner Jackson,
Yes.
Commissioner Roberts. Mr. Chairman, you have a majority yes.
All right. William Leesman, or is it, it might be Lesseman? Come forward, sir. Downtown Hyundai Subaru. Did I get it right the first time or the second time?
Leisman?
Leesman.
Yes, sir.
Yeah, welcome, sir. For the record, if the staff would read in the reason for the denial of the application to sell motor vehicles.
Applicant was denied on a felony conviction of aggravated assault, strangulation. End of sentence. The sentence date was April the 4th, 2013. Sentence was for 4 years. April the 4th, 2017 is end of sentence. April 4th,
So this applicant would be eligible.
April the 4th, 2022.
Leesman, could you describe the felony for which you were turned down your application?
Sir, I was living with this lady that turned into be a real bad alcoholic, and I was working at Town and Country Board, and she called the corporate office over there and said she was working with the state's attorney's office and the FBI, and if they didn't meet her demands, they were going to close her down. Well, then they realized that she sounded a little drunk, and she named off every person in management and in the office up there. And they just had a cow with me, and thought I had something to do with it. It's my job. Well, a couple of days later, I didn't know anything about it, and they finally got me in the office. I noticed everybody was acting funny and told me about it, and had found out and did all this research about her. She was a stripper and all this down here in Nashville. They'd found out about her and told me it was okay, just get rid of her. Well, in the process I was trying to do that, she was out in my truck, and my friends had called me saying she's over at their house, she's falling down drunk, what I do? I told them to take the keys away from her, and gave her a ride back to my place. When I got home, she was asleep, and she woke up, and she kept telling me all these fantasies about how she was expert in Taekwondo and worked for the FBI and all this stuff. It's just incredible. She's just gone nuts. Well, she wanted to leave. She's going to leave in this little Toyota I'd bought her, and I'd taken the spark plug wire off out where it wouldn't run before I come in the house because I knew she was drunk. Well, she called the law. I got my roommate to take her home, and law comes out there, comes to her home, and she's anemic, and I hadn't known that. She'd been living with me for a couple of months, but she'd bend over from me. I'd give her a little pat on the butt, and she got on me about that and showed me, she said, listen, I bruise so easily, you can't do that. I said, I thought she was kidding, and she took my finger and pushed it on her stomach. And you'd just go in just a little bit and it'd just go to mush. Never seen anybody that bruised so easily like that. Well, when my roommate took her home, she didn't have any marks on her neck. I had never hit a girl in my life. She went home, she went and scratched her neck, and it bruised up real good. And when she called the law.
I might interrupt you just a second, sir. Is this all building up to you're going to tell us you were innocent?
Well, I got convicted for it and pled guilty, but she didn't leave my house with any marks on her neck.
There may be more detail in here than we need, but you can continue down this path. But the reason that you feel the commission should grant you this license is because you're actually innocent of the felony for which you're charged. Is that where you're going with this?
Yes, sir. I've been a licensed salesman for almost 30 years, never had any problem with anybody.
Well, that's a long sentence, is it 9 years?
Gave me
I'm sorry,
90, to
four
do
years.
90 days and a $50 fine. And I had to sit in jail because I couldn't afford a $4,000 bond to get out.
That's a long sentence in a domestic situation. This is a felony assault.
Right.
I mean, so, but you're innocent of this.
Well, you know, I'll be innocent as far as I'm, till the day I die.
Here's where I think the commission weighs in on this. You say you're innocent, and you might be, but the courts don't say you're innocent. Now, I think the question for the commission to consider is, are you telling us the truth right now? I think we're more focused on the truth than we are how.
Pled guilty, it says on the sentencing report. Court-appointed attorney, Ms. Micah Catron, if all this was the case.
I would find it unusual to be innocent and then plead guilty and take 4 years. Let's see. I'm sorry that I'm so far behind on this, but you're convicted 2013, you're on probation until 2017? Okay. What are you doing now, sir?
I've ever done all my life.
Did you lose your job at Town and Country as a result of this?
I was, the same day as when I got arrested for that.
Why did you leave your previous place of employment?
I was arrested and couldn't make bond.
Okay, that's what I'm saying.
Are still employed at the same dealership?
Put it at downtown Hyundai Subaru.
How long there, sir? Okay. Other questions? Commissioner? Yes, Commissioner Bass.
Enlighten me here. You working at downtown Hyundai, you say, currently? Where you working now?
Not working. Since they denied my license, I couldn't work. I was working at downtown Hyundai Subaru.
Well, I've noticed on here, it said if you're currently working for another dealer, give the dealer number.
I was working for Town and Country Ford.
Okay, so you gave that dealer's number on here.
Right.
And then your license, salesperson license number, you're saying the same as the dealer's license
I
number?
misread that. I would put that down as I thought that was where you're supposed to put your salesman's license number.
I've got a question. You were sentenced to go to jail for 4 years, or you were given 4 years probation?
Probation. They gave me 90 days, but it was 6.5 months before I went to court. 90 days and a $50 fine.
And you were terminated at Town and Country Ford right after this event, or what?
I went back to work for them for a short time, and everybody was still up in the air about what this woman had done to them. I just couldn't get along with them.
Further questions? One here with you from the store. Would that individual like to speak to us, please? And you are?
My name is Kenneth Malley,
And your position at the dealership?
General Sales Manager.
Okay. Like to speak to your knowledge of this gentleman's
Will's worked with me before when I ran Champion Ford years ago. He worked for me for about 2 years there. I hired him over here. I don't know what his personal life is. I know that he's a good salesperson for us. He was working in the internet department. He does a very good job, comes to work on time, and he's no trouble for anybody and is a very productive person.
Much discussion, do we have a motion?
Chairman, I make a motion that we grant him his license.
Motion that we grant, the commission grant the license.
I second it.
Second from Commissioner Parr. Discussion of the motion. Hearing none, we'll have a roll call vote.
All right, a yes vote will be to grant the license. Commissioner Parr? Commissioner Purtle?
Yes.
Commissioner Cullum? Commissioner Bass? Commissioner Trickett?
Yes.
Vaughn?
No.
Commissioner Webb?
No.
Commissioner Jackson?
No.
Commissioner Roberts?
No.
Chairman, there's 5 noes, 4 yeses.
Application as a denial has been upheld. You may reapply it another time. Adam C. Rotero. Where's Rockstar Motors located, sir?
Dickerson Pike in Nashville.
In Nashville?
Yes, sir.
Okay. Could the staff read into the record the reason for denial of the application?
A felony conviction of aggravated assault and possession with intent to sell Schedule 6 drugs. Date July the 13th, 2000.
Schedule 6 drugs. Good.
Marijuana.
Right. Is it Rotero? Am I right?
Rotero, yes, sir. Rotero.
Rotero, excuse me,
Yeah,
Mr.
no
Rotero.
problem.
Would you like to speak to the commission for an appeal for denial of your license to sell cars?
Yes, sir. I don't have any excuses. February 17th, 1999, I shot a handgun in Sumner County at a road sign, and it struck a gentleman in his car. I was in possession of 2 ounces of marijuana and was arrested. I was sentenced to 8 years for aggravated assault and 3 years for the marijuana charge. I was sent to West Tennessee State Prison in 2000 and made it to Riverbend Maximum Security in Nashville. Changed my life in prison. I completely changed my lifestyle and outlook. I never was written up and never failed a drug test in prison. I started writing the judge and the victim. The gentleman that was vehicle who struck, I didn't know, I didn't see him. I was shooting at a road sign. The bullet hit someone's car about a mile and a half away. I wrote the judge letters, wrote the victim letters of, how repentant and sorrowful I was. 2 years into my 11-year sentence, the judge overturned her decision and let me out. I spent the next 9 years on probation, highly supervised, never was written up, never failed a drug test. I completed that sentence. And just recently, on the 18th of July this year, I was restored my citizenship rights by the same court. So I screwed up.
Questions for the gentleman?
How seriously was the gentleman that you struck with a handgun?
He was released from the hospital the same night.
So it was not a severe one?
No, sir. No stitches. They can't confirm or deny that the bullet hit him, but a piece of glass or something grazed him.
How have you been employed most recently?
I'll tell you from start to finish. I was employed when I got out by a gentleman, a friend of a family member who made car parts, and I worked in his warehouse for about a year. It hit a downturn, and I was laid off. And for the next 4 years, I knocked doors door to door for Kirby Vacuum and sold vacuum cleaners door to door for 4 years. They gave me a business because I was so successful. I had my own franchise there, and I got married to my wife, and we had a child, and just the hours were just too late night, and just it doesn't attract good employees. So I was having to hire people that were on drugs and alcohol, and they just the turnover was just too extensive. And so I was hired by a man in Brentwood that owns a credit card processing company, and I worked in a bank running their credit card processing. I was a sales manager for him, and he wanted us to move, and I'm from Nashville, so we didn't really want to move the family. And then I got into in-home sales and worked for Don Bruce at American Home Design in Gillisville for the last 4 years.
Gotten in any other trouble since this
Oh,
incident?
ma'am. And I have, I could have filled this courtroom with people, but I have character reference letters here.
Pass those out.
Yeah.
Start over here with Commissioner Jackson, and we'll questions for the applicant?
My counselor at River Bend is one of those letters, and there's millionaires in there that know me. There's business owners. I speak at the Federal Halfway House 4 times a year here to 200 inmates, and do as much as I can. I go back in River Bend, and they don't let prisoners back in the prison where you were there, and they make an exception for me. I brought
Someone from the dealership, sir?
No. Just give me a minute, please. I could have filled this room with people for speak on my behalf, but I brought one person that I was incarcerated with, Corvac Shaw, who spent 20 years in prison. He's been out 5 years. And he can speak to my character.
Here for Mr. Shaw. Is Mr. Shaw your name, sir? Come right ahead, sir. Welcome to the commission. Would you like to address the commission briefly?
Sir, I met Mr. Rodro in 2002 at River Bend.
2000?
Yeah, 2000. And he was like a common inmate, saying they never had trouble, and he helped inmates, and he went in prison, saying when he got out and was spreading the word to him, and he a good citizen, and he upright. I believe if y'all give him a chance, I know he'll do the right thing, saying he been positive, and I go and work for him, saying at his house, and he just been outstanding. Yes, sir.
Questions for Mr. Shaw before he sits down? Thank you, sir. Any further questions or comments?
Chairman, I move to approve his license.
Earl moves to approve the license.
Second.
Second by Commissioner Vaughn. Discussion of the motion. Hearing none, I'll call for a roll call vote.
All right, yes vote will be to approve the license. Commissioner Cullum?
Yes.
Commissioner Purtle?
Yes.
Commissioner Parr?
Yes.
Commissioner Trickett?
Yes.
Commissioner Bass? Commissioner Vaughn?
Yes.
Yes. Jackson?
Yes.
Chairman Roberts?
Yes. Congratulations, sir. If you'll contact the staff, your application will be taken care of. That concludes, sir, you want your letters back? Yes, sir. Yeah. If you'll get those from Commissioner Pirtle when he's finished with them. All right, I think that concludes the salesperson's license appeals. We are ready for the director's report.
Right, you'll find in your packet of information the discipline report for July, August, and September. And the dealers named and civil penalties collected in the cases where that's appropriate. That's after the money's been collected. So that's your usual case of unlicensed activity, misuse of temp tag logs, non-supervised employees, a whole variety of things that happened, and they've been happening same way, nothing new, but a whole lot of activity has been going on with the legal department. The caseload, complaint numbers are down substantially, and there have been dates that you have all given for 6 days of formal hearings next year. Let's hope to get that out of the way. You'll find the license information. The dealer number is up 38 from last quarter. A sign of good times, I hope. Distributor and manufacturers are up 12. Salespeople are up 425. Got 4 dismantlers and 1 more RV dealer. So there is activity being shown, adding employees and representatives of manufacturers. Permit time, we've had 13 issued since last quarter. Date where the September the 9th formal hearing was continued.
I have a question just about the student loan default, suspension of license. Explain that to me.
May I ask our attorney to speak to that?
Sure. It's the Tennessee student, there's a separate statute under the department statutes that says once somebody has defaulted on their student loans, they're provided all of this notice from TSAC. And they're given the opportunity to have a hearing as to the default. And what happens is generally those people do not show up. There's a small hearing in a room. They're found to be in default of their student loans. And by statute it says that when TSAC gives the department the letter showing the default, the commission shall suspend the license until they become in compliance. So all of our regulatory boards do the same thing, that they are handled administratively because the legislature doesn't give the commission the discretion to not suspend the license or bring it back. So they receive these letters out, and then they generally call us and we clarify for them that they have to go to TSAC, and there is a specific process in place of what they have to do in order to satisfy that. They can do a forbearance of the student loan or come up with some kind of a plan to make the payment, or completely pay it off. So that's what those are for. Yes.
Hard to pay it off when you've lost your sales license.
Questions further for the executive director?
Cricket, in response to your question to Attorney Glandorf,
Same statute for child support obligations also. But those usually come more cyclical than the student loan defaults.
Motion to approve the director's report. Sure. Let me grab a question.
Could we have counsel to explain to us this rather large fine on a settlement with Matthews in Clarksville, please? 60.
Want to do that in the legal report? Or do you want to do that now?
Does not matter to me. This one it was on a past legal report already.
Let's save that for legal review, I think, and then we'll get back to it. Okay, then we had a motion.
Commissioner Jackson, motion that we adopt the director's report.
Second.
Second by Commissioner Vaughn. All those in favor, say aye.
Aye.
Opposed, say no. The report's approved. Legal report, and why don't we start with Commissioner Pirtle's question first?
I believe it was in, I guess, July meeting, I believe, is when we received the authorization for the $60,000 civil penalty against two dealerships. Is Patrick here? Okay, you're in the back. If I get something wrong, I'm sure you will pipe in, right? Patrick is the his firm served as the attorney for Gary Matthews during this period. Two dealerships, one was in Clarksville and one was in Antioch, and what happened, the $60,000 just in generally was for that on every vehicle sale they were charging a customer benefit package, or it was titled as a C.B.P. on every vehicle sale. Well, I say every for the majority that we saw. For majority of vehicle sales, it was charged an accessory. It was a coupon booklet, and the price of it was $349. Okay, but $349 booklet, and we had a complaint where somebody, I believe it was in 2011, the initial complaint we received from a consumer saying that they were charged this and they did not request for it to be charged. And on the commission statutes, you cannot charge for an accessory unless they ask for it. And also the dock fee, of course, obviously you can charge a dock fee, but it must be listed. So in 2011, there was a consent order sent to Gary Matthews. That was the Clarksville dealership. Antioch dealership. Thank you, Patrick. For $5,000, and they paid that. A few months later, one of our inspectors was at the dealership in Clarksville, and he was doing an annual inspection and pulled some deal files and saw that that same product had been charged, and he knew that they had already signed the consent order. So it seems like, well, this is ongoing. It's at a different dealership, but we believe same type ownerships. But so we decided to do an investigation at that time, and I believe at that time that we began our investigation, Mr. Matthews states that this is the first time he has heard about it, that the consent order that they paid of $5,000 was never disclosed to him from management. They never saw it until one of their attorneys provided it to them, one of their different attorneys, not Patrick's office. So Mr. Matthews at that point in time did a halt. This is not going to be charged at the dealership up here or down in Antioch, and the one in Antioch was actually managed by O.B. Garland. Right. Okay. So our inspectors, what they did is they pulled 100 deal jackets out of all of the from the dealership. So we pulled 100 deal files, and I believe 98 of them had the CBP that was on there. And so then we determined, well, we now have to determine whether or not it was something that the customers required. So they attempted to cold call 100 purchasers and meet with them. And what they met with 19, I believe they met with and received affidavits from either 18 or 19 consumers that said, we did not request for this. Now, some of these were during the time period when we had the first consent order ongoing. So what we did is we determined the number of affidavits that we had from these consumers after they had the consent order signed, meaning they had agreed that they would stop doing this, that this was a violation, and so we calculated those, and that's when my office had been in contact with Patrick and Mr. Cameron, attorneys for Gary Matthews, and $1,000 for these deceptive acts, knowing that as part of the information that they gave us, Mr. Matthews was refunding any customer who came in who requested a refund. And I think it was like at the time, December 2012, it was $50,000 had been refunded. And that there was another documentation that they provided where they had at certain facilities, these were coupon booklets for services, that they had $12,000 worth of services coming through. So the people were actually utilizing some of these things. So the $60,000 was agreed to by both dealerships, and now the Antioch dealership was actually sold. Yes, okay, so it's actually sold. It's no longer part of the group of dealerships. And since then, I know that since we've sent that out, the civil penalty out, it's our PIO, our Public Information Officer, received information from reporters, other agencies that wanted a copy of the consent order. So we provided that to them, and I believe it's been reported, I think, in some newspapers. So I know that I know that the dealership in Clarksville has had people come in and request for refunds of this, and I know that, and Jason, I believe, had there was a process by which we told them they could get in contact with them and talk about it. But refunding of those policies was not part of our consent orders, because that's not generally within our within the purview of what we do, is attempt to monitor somebody for penalties. But
Thank you. I was absent in July. Thank you.
I'm sorry if that was too
Out of
long.
respect for Mr. Merkel, is there anything you'd like to refute in that, Mr. Merkel? Thank you. Thank you. Legal report?
Yes.
Today's legal report.
There were, from the legal report that was provided, there were 4 changes that were requested. For number, and I would like to note those changes now. For number 38, we would change the date November 2013 to November 2012. That's a correction. For number 49, we would add that my office would send a copy of this complaint to the Federal Trade Commission. Well, I would like to suggest the Federal Trade Commission and also to the TBI. For number 50, we will add to that authorization that my office contact the automobile auction regarding account authorizations, purchase authorizations. And for number 52, I would like to delete the sentence, respondent surrendered its motor vehicle dealer license, from the last sentence.
Questions about the legal review report? Commissioner Jackson chairs that committee and does a fine job. Is there a motion to approve the report?
Commissioner Jackson, motion to adopt.
Second.
By Commissioner Vaughn.
I figure I'll follow you.
All those in favor of the motion to approve the report, say aye.
Aye.
All those dissenting, say no. That report is approved. Anything under old business? Is there a Rules Committee meeting after this? I guess that would be old business.
1:30 is when it's scheduled for.
This room?
Yes.
All right. Is there any new business? Well, let me see what we're passing out. Is that the, or those are the rules?
This is the new business. It's, current landlord's gonna be.
New business. While we're passing this out, it's not always traditional that the chair recognizes distinguished people in our audience, and we always appreciate our audience being here. But today we have someone that's very important to me, who's in the automobile business, does a fine job for his family, our family down there. And his name is John Roger Roberts, my nephew. He's over there on the front row. The guy with the red face that I've embarrassed. John Roger is gives us all great hope for the future of the automobile business in Tennessee. He's a fine young man. Thank you for your attendance, Mr. Roberts. Okay. Mr. Noble, while we're entertaining ourselves here.
Al Noble, Tennessee Auto Dealer Association. Just wanted to bring it to light that one of our auction operators was killed in a motorcycle wreck last week, was buried over the weekend. David Bynum from Chattanooga Auto Auction, who was Tony Morby's partner, was killed in a bike wreck. Just
Owner of the auction down there?
him and Tony were the managing partners, and he was killed up in West Virginia, buried in Georgia over the weekend, just 3 weeks shy of retirement. Makes it a bad, very good operator.
Thank you for
Just wanted to
bringing
let
it
you
to our
guys know.
attention. Our sympathy, of course, goes out to that family. All right. Director Stribling, are you, oh, I'm sorry.
Yes,
Legal
this-
Counsel Glandorf, excuse me.
Thank you. This is not part of the legal report. This has to do with a change to the motor vehicle dealer application. There were two statutes that were passed that affect the motor vehicle dealer applications. Just in July, there was Public Act number 192 that was passed that indicates that the Motor Vehicle Commission is required to have every motor vehicle dealer make an attestation, signing an attestation, understanding certain changes in the motor vehicle dealer laws and all of the laws in general. The changes were that anybody who has the surety bond lapse and any their license could be revoked for that if you fail to maintain your surety bond, and also if you fail to notify the commission of your change of ownership or location, then that is also a revocable offense. They actually were not revocable offenses prior to, and the surety bond becomes a huge issue when you have dealers who may be operating months at a time without a surety bond knowingly. Well, what that did was that as part of that bill, it required the commission to put this statement on their form, and we're just asking for basically ratification of this statement, just approval to place it on there, which states that we have to put failure to maintain a surety bond as required by 55-17-111 or notify the commission of a change of ownership or location required by 55-17-113 may result in the assessment of a civil penalty and or suspension or revocation of a motor vehicle dealer license. It was a bill for notification. So part of what I would like to see is a motion to approve that, and then also as part of that is on the front page, you'll see the beginning of the documents. You'll see what is a 3-page form, which is eligibility verification for entitlement acts attestation instructions. And what this is the entire department is doing this, and it is required by a statute that was passed last year. So a little over a year ago, the Tennessee legislature said that all regular professional licenses are required to verify that the person who's receiving the individual license for a person is either a U.S. citizen or they're a qualified alien, because currently that's not the case. It's required under federal law. So this is, it was required already under federal law. The state of Tennessee says that we're now mandating all of our regulatory boards to follow that federal law. And this is basically the universal form that the department is going to utilize. The department, in order to actually fulfill this function, is attempting to right now enroll into a federal program called the SAVE program, S-A-V-E, which will allow people from our department to utilize a database that will have all of these immigration forms and information in there to attempt to verify some of these documents that we receive right now. So what this 3-page form does is it basically sets out the procedure that when somebody applies for a license, they now have to give us some kind of documentation. If they say they're a U.S. citizen, then give us Tennessee driver's license, passport, something, birth certificate, something like that. And then it says, oh, but if you're a qualified alien, then you have to give us 2 pieces of documentation to show that you're qualified to work here. And it gives a list of these types of documentation, and then they provide those documentations to us. The reason we would use that SAVE database that I mentioned, if they could only provide 1 piece of documentation, then we would run that through that database. But the way that the law was created for this SAVE, or for this U.S. citizenship or qualified alien verification. The way the law was written, it says that the next time any one of these boards or commissions change their form or are required to change their form, they must start asking these questions. Well, we're now into the position where we're required to change our form because of the July statute, so we're required now to ask these certain types of questions for citizenship verification. And like I said, this is actually a departmental run. This is not something that has been put together by Mr. Stribling's office. This is actually the Assistant Commissioner's office who's been developing this with my boss. So.
Requires no action on our part.
Other than probably a motion to approve these types of changes in their substance so that we can change our form, because under the Motor Vehicle Commission statutes, it says that the commission shall create and change forms, so.
How would we word that, how would we word such motion?
Probably a motion, change the motor vehicle dealer application form, substantially complying with, these documentations that have been provided.
Pushing from
Yeah, that's what I was about to say.
So moved.
And let's
Get
attempt
over
to.
back there.
Where's the wordsmith on this panel here?
Well, I guess it would be
I
just
just make
a,
a motion that we accept the recommendation of legal counsel for the adoption.
Questions or discussion?
Just one question on
Yes,
the
sir.
last document. What failure to maintain a certificate with application.
yes, the wording in bold is actually added to the application.
By voice vote, those in favor of the motion say aye.
Aye.
Opposition would say no. We have none. Under new business, let me get back my tablet just went off. Talked too long and didn't read enough. All right. Hearing no further new business, we'll entertain a motion to adjourn.
So moved.
Okay, this meeting is adjourned. Thank you for your attendance. Man, my tablet.
Technically, we should be able to go home.
Take so heavily.
Here you go. I'm just here to be helpful.
I was just slowed down.
I don't know what it was, but I mean, I was 9:15.
Well, it was really slow. I came up.
So glad he's here. When I saw him, I was like,
GPS that I think
it looked like I was smiling at whoever's standing up there. I was like, oh, that's good.
I'm always embarrassed.
Oh, it's fun to do.
It's fun, but I'm not sure I might lose my title after the
That's my Uncle Joey.
Yeah.
I used to go with him to pick up women. It was nice.
Thank you, Chairman. Good job. All right, we just leave our stuff here and come back here.
Yay! Here, seriously, I've had like 5 bottles of water. I was ready for a break.
Yeah, you're gonna be running to the
I was
girls.
like, oh my God. Can we stop talking?
I'm so accustomed to saying son-in-law.
No, that's all I used to do.
I'm continually embarrassing you.
I did a little cheer to support him.
So I did it too. Yeah. You think that was exciting? We're gonna sign.
Get up for that red apple number.
Back here and I'm on my phone. I Google it. Little bitty blur.
The thing is, I'm not actually.
When you get caught.
I'm here. Back when.
That's Robert. Is he working in your business? How you doing?
Nice to meet you.